Good morning, everyone, and welcome to day one of the ADA webinar series. My name is Mike Fitch with the Ohio LTAP Center here at ODOT, and we appreciate your participation. As we get started, please take a moment to locate the questions box in the GoToWebinar panel. During the presentation today, please use the questions box to send in any questions you might have. Looking at the handout section of the GoToWebinar panel, please note also that 3 PDF resources are available for reference. With that, we will go ahead and turn things over to Ron Eck. Hello, Ron.
Hello, Mike. Thank you, and good morning, everyone. Welcome to the ADA Self-Evaluations and Transition Plans. As Mike said, I'm Ron Eck. I'm with the West Virginia LTAP Center and joining you this morning from Morgantown, West Virginia, which is where the center is based. I'm an engineer. That's my background, a civil engineer, traffic engineering, and road safety, and also accessibility. My email address is shown there, so feel free after the session, if questions or concerns come up, feel free to reach out. I'm always glad to try to assist. And at any time, if you have questions or concerns today or tomorrow, please use the chat, and Mike will interrupt me, let me know we have some questions, and we'll be glad to take those at any time. Here's what I hope you'll get out of the sessions today and tomorrow. I hope you'll be able to identify a local agency's responsibilities under the Americans with Disabilities Act, Section 504, and other laws relating to accessibility. Also, I hope you'll be able to either create, if your agency doesn't have a transition plan, or if you do, you'll be able to revise and update your transition plan and conduct a self-evaluation for your agency's facilities in the public right-of-way. Here's our agenda, overall agenda for both today and tomorrow. We'll start out with some background and history of ADA. I'll try to keep that brief. We'll talk a little bit about enforcement and some significant court cases that relate to accessibility in the public right-of-way. Then we'll get into the self-evaluations. What are the requirements and what are the contents of a self-evaluation? Same thing with transition plans. We'll look at the requirements and then what makes up a transition plan. Then we'll look at a transition plan case study. And one of the 3 items, handout items that Mike mentioned that are available to you is a transition plan for the Village of Lyons, New York. And we will use that as a case study. So as a heads up, a little homework assignment for everyone. If you would, please read or at least skim that Village of Lyons transition plan for tomorrow's class. Hopefully that will facilitate your understanding of the review of that transition plan. I should also note that that's included in your handouts, not because it's an example of a model transition plan. It does have some weaknesses, and that's why we're using it as a case study so we can do a little critique of it. So again, I want to emphasize that's not considered a model plan. It's one we're going to use for our case study. And then we'll wrap up tomorrow by looking at your agency's transition plan to-do list, and probably each of the agencies represented here today is at a different point in terms of the self-evaluation transition plan process. So each of you may have a different to-do list, and we'll talk about that. And I realize today, mainly, or maybe also next time a little bit, talking about laws and enforcement, court cases, may not be the most exciting topic. So what I'll do periodically is put up a photograph with the caption, "What do you think?" And we'll use that to kind of break up the topics, but also use it maybe for some teaching moments as we go through and talk about ADA. And I'd welcome your comments and questions regarding these what do you think images as well. So this first one, this is a city in West Virginia, and I wasn't involved in this project, but as I understand it, what happened here is that the gas company, a few days before I took this photograph, was working here to repair or replace a section of gas line beneath the sidewalk. And their practice is to, backfill the trench and then place some stone on top of it. And then, and I think this is probably common elsewhere in the country, but then the gas company submits what they call a ticket to a concrete construction company that I guess is on contract with the gas company, and that concrete contractor has 2 or 3 weeks to come in and restore the finished concrete surface to the sidewalk. But my concern, and the reason I show this photo, is in that 2 to 3 week period before the concrete is put back, this is what it looks like. It's a sort of loose stone on the surface, and that loose stone is not an accessible surface. Someone in a wheelchair or maybe someone using a walker type device probably cannot negotiate that surface. So as you see it here, this is an inaccessible sidewalk. So what might be done, or how could this be handled? One way might be perhaps to put steel plate over the excavated area to sort of bridge over and provide an accessible surface. However, of course, steel plate when it's wet can be very slippery, and so we'd need to do something about slip resistance. We could maybe also put a boardwalk over that area. Timber also gets slippery when wet, so that would be an issue. Maybe something else, maybe the gas company, rather than leaving stone on the surface like this, maybe they could use a cold patch type material. It wouldn't be certainly permanent sort of asphalt, but at least it might provide a firm, stable surface until the concrete can be restored. So that might be something to explore. Or as part of that, they might also explore, is there a way to speed up the process so that things could be done more quickly to get a finished surface restored. So you can see, I like to say with ADA, the answer often is it depends. It depends on the specific circumstances and situation involved. Well, let's start with a little background and history of ADA. ADA is a civil rights act. And so in terms of predecessors to ADA, probably one of the landmark items of legislation in the United States was the Civil Rights Act of 1964. But interestingly, it didn't address individuals with disabilities or accessibility. However, at that time, meaning back in the mid to late 1960s, there was interest in accessibility and making facilities accessible to everyone, including those with disabilities. And so one of the important items of legislation back then was the Architectural Barriers Act, which said that new federal facilities had to be accessible. So for example, courthouses or maybe recreational facilities needed to be accessible. Then in 1973, the Rehabilitation Act was passed, including Section 504, which I've already mentioned. And that's significant because it said programs and facilities funded with federal money must be accessible. So this is why you see, and maybe some of you have such facilities in your community, back in the late 70s, early 80s, when maybe Federal Highway Administration funded streetscape programs in combination with state DOTs, these facilities needed to have curb ramps if federal money was involved. Now, those ramps probably don't comply with the current criteria, but they did comply with the criteria that existed back then. And then in July of 1990, President H.W. Bush signed the Americans with Disabilities Act into law. So we're approaching here in a few months the 35th anniversary of ADA. And as I said, it's a civil rights act intended to provide equal opportunity for individuals with disabilities so they can access the same programs, services, and facilities as any other individual. And the requirement under ADA is that all programs, and programs include sidewalks and signals, crosswalks are considered programs under ADA. All programs and new and altered facilities, regardless of the funding source, need to be accessible. So if it's in the public right of way, and even if it's all private or local money, those facilities still have to be accessible. And the United States Department of Justice, DOJ, has ultimate compliance responsibility, and we'll talk more about their role here as we go through the program. As you're probably aware, ADA is pretty comprehensive. It includes things like employment, telecommunications, and here you see the parts of ADA, and the part that we're interested in is Title II, which deals with state and local governments. And I've not seen the roster for today's class, but I'm willing to bet everybody in attendance is either with a state or local government, or if you're with the private sector, you're with a consultant or a contractor that does work for and with state and local governments. So I think everybody that's here today is probably interested in the Title II aspect. But even Title II, you can see, is pretty comprehensive and also gets into employment and compliance and other things like that. But for our purposes in the public right-of-way, we're going to focus on Subpart D, which deals with program accessibility, and Subpart E, which deals with communications. So let's look at each of those. Subpart D, dealing with program accessibility. The Code of Federal Regulations, Section 35.151, addresses new construction and alterations. And it says each facility constructed by, on behalf of, or for the use of a public entity shall be designed. There's a word shall, so it's not just something nice to do, it's a requirement. Shall be designed and constructed in such a manner that the facility is readily accessible to and usable by individuals with disabilities. And so those last few words there are really the bottom line when it comes to kind of the standard that an agency, a public agency, would be held to, is are those facilities readily accessible to and usable by individuals with disabilities? And we'll talk more about that. So here's another what do you think image. This is a town in central West Virginia. I visited a few years ago. They invited me in to do sort of a walkabout with them. It was interesting. The mayor and the council members were there, the planning commission, some interested citizens. And you can see it was a nice fall day. We had a nice walkabout. Their focus originally was safety and aesthetics. They wanted to have an safe and attractive streetscape. I'm not sure they had thought much about accessibility, but since I was involved, I brought up and emphasized that safety and aesthetics were important, but also accessibility was vitally important. And as we were walking, we came to this street corner, and you can see we have a barrier here. There's no curb ramp. And I sort of like the photo because I think that's the mayor on the right there, and I think the woman in the dark sweater is the planning commission chair. But the woman with her hands on her hips is Mary. She's a council person, and she's standing now for a short time, but Mary has some issues with her knees or legs that she can't negotiate steps. Even a single step, like off of that curb, would be an issue for her. So she actually had been in the wheelchair that you see there, that's Bob, her husband, was pushing her in the wheelchair all afternoon. But at this point, of course, we encountered a barrier, and that's not a good situation to have a curb without any sort of ramp to move between the sidewalk and the street. So this certainly would not comply with the subpart D requirement that I just read to you. But that's one thing, is accessibility, which of course is important. But this slide also allows me to emphasize another point, and that is that the ADA requirements are just that, they're accessibility requirements. They're not necessarily safety related. And so it's up to us as professionals to use our knowledge, our experience, our training to also incorporate safety into these projects. And if you look here, I'm going to get my pointer so everyone can see my pointer. Notice this crosswalk here. As a traffic engineer, this kind of bothers me. Notice how it's kind of sharply skewed at an angle here. Normally, a crosswalk should cross the street at right angles to minimize the crossing distance, minimize the time that pedestrians are exposed to potential traffic conflicts. But this is at a skewed angle and certainly doesn't minimize the time the pedestrian is in the roadway. In fact, it would increase it. But also notice if I'm walking kind of from the right to the left, because of that skewed angle, I may not really see a vehicle coming, say, making a turn here, coming from behind me. And so it makes it more difficult for pedestrians to detect vehicles. So I really have two concerns on this corner. One is the lack of the curb ramp, but the second one is the crosswalk location. So it's kind of an accessibility issue and also a safety issue. I mentioned earlier the subpart E, which deals with communications. And here's what the Code of Federal Regulations says. And notice the word shall in here again. So it's a requirement. A public entity, state or local government, shall take appropriate steps to ensure that communications with applicants, participants, and members of the public with disabilities are as effective as communications with others. And that can have a variety of meanings. We're going to focus on the public rights of way aspect of the communications. And here's an example of that. An individual sent me this photo a couple years ago and asked, his question was, Ron, we're going to be doing some utility work on this sidewalk section here that I'm highlighting. So we're going to be closing this sidewalk and sending pedestrians on a detour route. Is that sign acceptable? And my response was, well, that sign is an official sign. It's in the manual on uniform traffic control devices. But the problem with that sign is it doesn't comply with subpart E because a blind pedestrian cannot see that sign. A blind pedestrian cannot access the information contained on that sign. And so the correct way, the accessible way to close a sidewalk is to have a detectable barricade across the entire width of the sidewalk to let the visually impaired know that the sidewalk is closed. You can also have the sign, but the sign by itself doesn't comply with subpart E because it cannot be read by a visually impaired pedestrian. So you need really the barricade, and then you can also use the sign. ADA, or some of the standards involved, are identified here, and I appreciate that it can be a little confusing at times. So let me kind of explain where each of these standards, if you will, is applicable. The first one that's listed there is UFAS, the Uniform Federal Accessibility Standards. These came out of the Architectural Barriers Act of 1968. And basically, local governments and state governments don't need to worry about UFAS. This would apply to federal facilities. but they are ADA, or they are accessibility standards, if you will. The second one there, the Americans with Disabilities Act Accessibility Guidelines, or ADAG, or the current version is the 2010 ADA Design Standards. These are accessibility standards that pertain to buildings and sites. Buildings and sites. The next item on the list is PROAG, the Public Rights-of-Way Accessibility Guidelines. And the final rule on PROAG was issued in August of 2023. We're still waiting on DOT and DOJ to adopt PROAG before it can be enforced, but we do have the final rule. And as the title implies there, PROAG applies to the public right-of-way. So sidewalks, crosswalks, traffic signals, roundabouts, on-street parking, all of these things are covered by PROAG. And what makes it maybe potentially confusing is that for those of us in public works with state or local governments, we really need to look to both of those because, while of course state and local governments have areas in the public right-of-way, sidewalks, crosswalks, traffic signals, and things such as that, those of you with state and local governments also have facilities open to the public, correct? Like a town hall or city hall. If you're with a county, you have a county courthouse. County and towns and cities, you may have libraries. So these would need to fall under ADAG for buildings and sites. Or for example, DOTs have rest areas along interstate highways. Those would fall under ADAG. And so really a public works entity has to be familiar with both ADAG and PROAG. In this session, though, we're going to focus on the public right-of-way, so we would be looking specifically at PROAG. But as I just have tried to explain, determining which one applies to your assets does require a kind of a careful look. And oftentimes, I like to say it's the interface or the boundary between the public right-of-way and the building or the site where we sometimes run into challenges or difficulties. A term you may have heard, may be familiar with, or maybe not, is technical infeasibility. This means something that has little likelihood of being accomplished, or maybe what I should say is because of the situation, it's difficult to comply with the PROAG criteria because of some constraint. It could be right-of-way, it could be drainage, it could be utilities, it could be a historic structure, but it prevents us from complying fully with PROAG. But what ADA requires is that we still need to provide an alternate access route or accessible services or an accessible facility to the maximum extent feasible, and then document why we couldn't comply with the specific requirement and show that it is accessible to the maximum extent feasible. So documentation is critical when it comes to ADA, especially when we're talking about technical infeasibilities or exceptions, as some people call them. So here's an example of a technical infeasibility. I was not involved in this project, but I know a little bit about it, so we'll talk about it. And actually, the whole thing starts with a roadway that's off the left side of the photo here. In this community, there to the left, out of the view of the photograph, is an arterial street, carries a lot of traffic, and probably about 20 years ago, the road agency determined that they needed to add an additional traffic lane. And so they reduced lane widths, but also they reduced slightly the width of the sidewalks on both sides of the street. They're still 4 feet to 5 feet wide. They still comply with PROAG. But what happened when they reduced the width of the sidewalk, they had to steepen the cross slope of the sidewalk. such that it was, I think, on the order of 7 or 8%, much higher than the allowable 2.1%. And again, that was done probably 20 years ago. Well, then maybe 5 years or so after construction had been completed, someone, actually more than one person, and groups of advocacy groups complained to the road agency that, hey, you made this sidewalk inaccessible. It's wide enough, but the cross slope is so steep that people with mobility devices are not able to safely or comfortably use the sidewalk. It needs to be rebuilt to a 2.1% cross slope. At first, the agency declined to do anything, and so you might not be surprised to know that these individuals and groups filed a lawsuit against the road agency. And that worked its way through the courts for probably 5 years or so. And then, I guess just before COVID, or as COVID was starting, the court issued its ruling. And the ruling was that this municipality had to rebuild the sidewalks for 3 or 4 blocks along this arterial and make the cross slope 2.1, no steeper than 2.1%. So what you see here is actually construction was still underway. I guess this block had been completed, but you can see this is relatively fresh concrete here. So, and you can see how they had to lower the back edge of the sidewalk to reduce the cross slope. So this is 2% cross slope here. But notice here we have in the sidewalk, I'll call this an obstruction. It's a utility pole, such that the distance from the pole here to the storefront is 42 inches. ProAg requires 48 inches, so this does not comply with ProAg. And of course, one solution would be to relocate the pole, but in this case, there's a line of utility poles for several blocks, and the road agency in this case, their argument was the court ordered us to make the sidewalk cross slope 2%. They did not really address the width issue. So relocating the line of utility poles would be outside the scope of this project, outside the scope of what the court ordered. And so further, they went on to explain in their documentation of this technical infeasibility, they said, it's true that ProAg requires 48 inches, but this is 42 inches. And under ADAG, remember ADAG is for buildings and sites. In ADAG, the minimum width of the access way is 36 inches. So a wheelchair can use a 36-inch wide opening since that's allowable under ADAG. So their write-up went on to say, so even though this doesn't comply with ProAg, it would be wide enough under ADAG, and therefore it is accessible to the maximum extent feasible. And so if you look at the project files on this project, you see technical infeasibility write-up, including the documentation of what I've just mentioned to you, photographs, maybe sketches, that sort of thing that were undertaken or prepared as part of this assessment. So that's how technical infeasibility works. Sorry for that long discussion, but I did want to explain how technical infeasibility works. So that's some background to ADA and some terminology. I mentioned we'd talk a little bit about enforcement, and I mentioned that DOJ is the primary agency when it comes to enforcing compliance. Fortunately, they tried to reach settlement negotiations first before there would be a federal lawsuit. But notice there are some penalties, financial penalties associated with non-compliance. Another enforcement or compliance agency is the United States Department of Transportation, notably in our case, the Federal Highway Administration, where we're talking about the public right-of-way. And each division office, So in Ohio, it would be the division office. In Columbus would, or in West Virginia, it would be the division office in Charleston, West Virginia, my state capital. They would investigate complaints. They also provide technical assistance and other compliance-related activities. So their investigators may come to your community to investigate a complaint, or it could be DOJ could come to visit. The U.S. Access Board is also involved, since they develop and issue these various guidelines and requirements. You can see they've been involved in it for a long time, even preceding ADA in 1990. But ADAG, the first issue of ADAG in 1991, that was developed and published by the Access Board. As I mentioned, right now we're operating under the 2010 version of the ADA design criteria, or ADAG. PROAG was first issued in draft form in 2002. It was revised, but still in a draft form. The latest was in 2013 when they incorporated multi-use trails into the document. And as I mentioned earlier, the final rule of PROAG was issued in August of 2023. But another group that's involved, or another entity that's involved with enforcement of ADA, if you will, are citizens or citizens groups or advocacy groups. And their involvement is they're the ones that may file complaints or file lawsuits regarding accessibility issues. So that's their role in the process. Before we get too far into this topic, I did want to just talk a little bit about some of the impairments that affect the ability of people to access programs, services, and facilities. And of course, maybe many are familiar with the physical or orthopedic type impairments that may require someone to use a cane or a walker or a wheelchair or some other device. These, of course, an individual with these conditions or impairments, they use the assistive device, so it's kind of apparent to everyone that this individual has a mobility impairment. But there are other types of impairments, especially kind of maybe cardiopulmonary sorts of impairments, where the individual may not have any outward indication that they are disabled because of their condition. Then, of course, we have vision. There's two main categories of vision. There's blind pedestrians. And here there's kind of two subcategories. Maybe the iconic one is the use of a service animal or guide dog to assist the individual in navigating the built environment. But the truth is, actually, really a relatively small percentage of blind pedestrians use a service animal. Most use what's called the long cane or the white cane to navigate. And so they use the cane to be able to navigate the built environment. But there's another category of vision impairments called low vision. And these individuals are not legally blind, but their vision is very poor. For example, just even corrected, they would not qualify for a driver's license just because their vision is so poor. So they rely on colors or contrasts and also textures to be able to navigate the built environment. And typically, a low vision pedestrian does not use a cane. So to those of us sighted pedestrians, they look like just another pedestrian. We really don't have an indication that they have serious vision impairment. Another sensory impairment is hearing, and of course this can vary from kind of hearing impaired to total deafness, quite a bit of variability there. And then the last category of impairments are the cognitive or neurological. These are things that affect, conditions that affect information processing and decision making. An example is a traumatic brain injury, for example, that might be sustained in a car crash, or some of our veterans coming back from overseas may have sustained traumatic brain injuries. But also autism. There's a broad range of severity, degrees of severity of autism, the autism spectrum, but autism is a cognitive or neurological impairment. So the point is, you can see a lot of different types of disabilities that affect people using the built environment. And I like to say everyone benefits from curb ramps. Curb ramps, the courts and DOJ consider curb ramps to be the basic element of accessibility. Everyone benefits, I just mentioned that. Ohio has about a 14.4% disability population. National average is about 12.8, so you can see Ohio slightly higher than the average. And I should caution, when you look at disability statistics like this, you should always ask, what's the age group that we're talking about? And I apologize, I should have mentioned this here, but those numbers that are in the second bullet, those are kind of from birth to death. So that's over the whole lifespan of individuals. That's the proportion that have a disability. Some of you with good memories, and if you've taken my Designing Pedestrian Facilities for Accessibility class, there I think I talk about 20 to 21% population, disability population. And so you might say, well, how come the difference? Well, the difference is these numbers on the screen here are birth to death. That 20 to 21% is age 15 and above. And so you can see how the proportion varies depending on the age. If I said, let's look at people just 65 and above, that disability population rises to 40%, which is not surprising. Of course, as we age, our physical and mental capabilities may decline. And so the older we get, the larger the proportion of the population that we find has a disability. But people may have temporary disabilities. Maybe some of you have been in this category. If you had an injury or had some surgery or something, maybe temporarily you're on crutches or have to use a wheelchair for a week or so, or a walker or something like that. So temporary disabilities occur not uncommonly. It's also important, I think, to encourage visitors or economic development in your community. Many communities these days try to attract retirees to the community. You know, come to our community to retire. We have a lot to offer in terms of programs and activities and so forth. And that's good. That's a good thing. But remember, as I said, say over age 65, 40% of that population group may have a disability. And so providing accessible facilities then becomes even more important. And last but not least, these requirements for accessibility are the law. And if they're not complied with, there can be penalties and other sanctions, if you will, associated with that. And we'll talk about some of these here shortly. Also, I wanted to show this. This is disability prevalence in Ohio. Again, this is all ages, birth to death. You can see the most common disability is the ambulatory disability, 7.3%, or what's that? Roughly 1 out of every 14 individuals in Ohio has an ambulatory disability. Cognitive disability ranks second, and then hearing and vision follow that. And this is for Ohio, but actually if you looked at most other states, the numbers and the order of the ranking are pretty common. So Ohio is not unusual in that regard. Now let's look at some significant court cases that relate to accessibility. And this is just a very small snapshot. There's maybe 4 or 5 or 6 that I've selected, and these will be presented in chronological order. The first one is over 30 years old now, Kinney versus Jerusalem. This was the city of Philadelphia, and both the city and the state would resurface streets, but did not either include or upgrade curb ramps at the corners. And so the lawsuit was filed against both the city of Philadelphia and PennDOT, Pennsylvania DOT. In fact, Jerusalem there listed as the defendant. That was Howard Jerusalem. He was the DOT secretary in Pennsylvania at the time. And the significance of this case, and we'll talk more about it tomorrow, is that the court established a definition of alteration, meaning if a street was resurfaced, that was considered an alteration, and the curb ramps along that street that was resurfaced needed to be brought into compliance as part of the project. And as I say, we'll talk more about that tomorrow. But one other point I should mention about this is that both the city but these requests were ignored. And that's actually what triggered the lawsuit. People just got so frustrated. They said, if you won't work with us, to install curb ramps, we'll see you in court. And that's what happened here. Moving to 2004, the case of Barden versus the city of Sacramento. Maybe you've heard of this case. This was widely publicized at the time. Curb ramps were involved here as well. Those communications were ignored, but it also got into the width of sidewalks, abrupt level changes such as sidewalks heaved up by tree roots, excessive cross slopes, overhanging obstructions, all sorts of things that limit accessibility were at issue here. This case settled before the court made a ruling, so this is a settlement. But the settlement, you see there in the second bullet, basically 20% of Sacramento's annual transportation fund for 30 years was to be allocated to pedestrian accessibility. So this was in 2004, so they are still in that program, if you will, until 2034. So I call that sort of external control of your budget, that 1/5 of their annual transportation budget needs to go to pedestrian accessibility. And also notice upgrade to curb ramps as part of street resurfacing is outside of that 20%. So this was had a significant budget impact on the city of Sacramento. But again, one of the common issues was that requests or complaints from the public for curb ramps and other accessibility features were not responded to. Moving to 2008, we have the case of Californians for Disability Rights, CDR, versus Caltrans, the California DOT. You can see that the lawsuit asserted that Caltrans had failed to survey its 25,000 miles of sidewalk and therefore could not know what access barriers existed. And the court said lack of a transition plan by itself constitutes a violation of ADA. So these transition plans are critical. And that's why we're here today and tomorrow to talk about that topic. I hope most of you have transition plans. If you don't, we're glad to see you here at the class, and I would urge you to get started as soon as possible on preparing the transition plan. And in fact, give yourself credit for attending the session today and tomorrow as kind of the first step in your transition plan preparation. Then in 2009, there was another case involving CDR versus Caltrans, and I just included this to show sort of the magnitude of what's involved here. The court ordered Caltrans to spend over $1 billion over 30 years on 10,000 curb ramps to be installed, retrofitting 50,000 existing ramps, reconstructing hundreds of miles of sidewalk, audible signals for the blind, temporary pedestrian routes, which is referring to work zones, sidewalk work zones, temporary traffic control. So again, it's kind of external control of Caltrans' budget. So I'm not trying to scare anyone, but just to show what can happen if we don't take these things seriously. And then a more recent one within the last 5 years or so was the American Council of the Blind of New York versus the New York City DOT. And as you see in the second bullet there, New York City has or had at that time over 13,000 signalized intersections, but less than 5% of them had accessible pedestrian signals, meaning the audible signals at the intersections. Again and again, a common feature of this case, like the others, was over the years, the city had received numerous complaints and requests for the audible signals so that folks could navigate the sidewalks of New York City. And so this was probably around 2015. So that was, what, 25 years after the passage of ADA, and New York City still had a very small percentage of their intersections that had the audible signals. So the federal court ruled that New York City did discriminate against blind and low vision pedestrians by failing to make crosswalk signals accessible. So that was what they called the ruling. And then a little over a year later, the court issued what they called the order or the remedy. And you can see the order here directed the city to have installed by the end of 2031. So that would be 10 years after the order. They had to install APS at least 10,000 of its signalized intersections. And I think they had roughly 1,000 of their intersections had APS. So that means in 10 years, they had to install APS at about 9,000 intersections, signalized intersections. Again, external control of your budget. And you can see there were annual targets set out. Compliance is going to be monitored by the courts. And so, again, it's something you don't want to have happen in your community. So it is important to show that you're making a good faith effort to address these matters. One other thing I wanted to mention is something called the Department of Justice Project Civic Access, where the DOJ visits states and communities around the country, including Puerto Rico and the District of Columbia, and they look at various ADA issues, not only the public right-of-way, but employment, communication, voting, polling places where people vote, all those sorts of things. They have been to every state, I think, by this point. And if you and maybe some of you have been visited by them, but if you're interested, if you just Google DOJ Project Civic Access, you can find the list, state by state list of everywhere where they have visited. But you can see there in that first bullet the sorts of things they're looking at. And the goal is to get compliance by counties, cities, and towns so that facilities around the country are accessible. And I just took a very small sample of three different kind of governmental entities, if you will, and what the issues were. The first one is DOJ versus the city of Frederick, Maryland. They're just on the fringe, I think, of the Washington, D.C. metro area. And they had issues with curb ramps. Apparently when roads were resurfaced, they did not upgrade the curb ramps. So the Department of Justice gave them 30 months to fix all curb ramps for roadways altered since January 1992. The second one I picked is the DOJ versus the town of Warrenton, Virginia. You can see a town of about 10,000 people. They're in central Virginia. They were given 3 years, again, to fix curb ramps. I'll emphasize, curb ramps are considered the basic element of accessibility, so we probably should give top priority to curb ramps. Notice they require training. As a trainer, I hate to think of training as a penalty, but DOJ will and Federal Highway Administration will require agencies that have been investigated, if there's problems, they may require that the employees undergo certain training. So again, the fact that you all are here today shows you're kind of being proactive, and make sure in your community or your entity that the training is being documented, and to me should be part of your next transition plan, because that shows you're making a good faith effort to address accessibility. And then sometimes people say to me, well, you know, my community, we're so small, no one's going to notice us if we're compliant or not. And I beg to differ with that my last bullet here is DOJ versus Craig County, Virginia. The county population is 5,200, sparsely populated, rural county in southwestern Virginia. They don't even have any roads, if you will. Counties in Virginia don't have road responsibility. So their facilities are more parking lots and buildings and that sort of thing. But notice DOJ found some issues and gave them 1 to 3 years to install curb ramps at buildings. Probably there were no curb ramps between, say, the parking lot and the courthouse, or the parking lot and the county library, the case might be. But in all cases here, we have penalties, fees, and that external control of priorities that I've talked about. And these can be minimized if an agency shows that it's making a good faith effort. And after my next example, we'll talk more about that. Here's another what do you think photo. This is a town in West Virginia. Their main street is here off to the upper right. So this would be one of the sidewalks along Main Street. Again, I was not involved in this project, but my guess was that I took this photo probably about 2 weeks after this street, which is off of Main Street, was resurfaced. You can see relatively fresh asphalt here. And remember, we talked about under Kinney versus Jerusalem, when a street is resurfaced, the curb ramps should be brought up to current standards as part of that project. Well, I think you can see here, we have a curb ramp, but I notice at least a couple things not quite right with it. Number one, notice there's no detectable warning surface. There needs to be detectable warning surface everywhere the curb is missing at a street crossing. But also notice, and we're not going to get into the details of curb ramp design and things in this class, but one of the requirements of a curb ramp is that it have a level landing where those with mobility impairments can make their turn. It's very difficult to turn going up or down a slope or a grade. So this ramp doesn't have a detectable warning, nor does it have a level landing. So this is a non-compliant ramp. But if we look a little farther, it also raises several questions for me. Number one, I'm not sure why they didn't put the curb ramp over here on the right. That's where it'd be in line with the pedestrian path on the sidewalk. And there may be a good reason why it's not there, but I hope that's documented. But another issue I see, or another question I have, is how does someone with a mobility impairment who's walking on Main Street, how do they get to this curb ramp? Notice with the light pole here and this column or drainage pipe or whatever that is for the building here, it doesn't appear to me that there's a 3-foot opening. And in the public right-of-way, actually, it should be 4-foot opening to move from this sidewalk to the curb ramp. It may be that someone could, it appears there's an opening behind where that bicycle is leaning against the wall there. So maybe someone in a wheelchair could come through this vestibule, if that's what we call it, to get to the curb ramp. But this is probably private property. And what happens if the property is sold, or what happens if the owner reconfigures the building? That path may no longer be available. So there's a number of issues that I see in this particular image, but the key thing I want to emphasize is that when we resurface a street, the curb ramps need to be brought into compliance. So I mentioned earlier, showing a good faith effort will help you avoid these penalties, fees, and external control of your budget. So what exactly makes up a good faith effort? This is my list of what makes up a good faith effort. And maybe the most important item, since we looked at it in that one lawsuit, is to have an up-to-date transition plan. In fact, it's my understanding from talking with FHWA officials from various states that if they are investigating a community, their first question will be, show us your transition plan. And if you can show that you have a transition plan, it may not be up to date, but if you can show you have a transition plan, that goes a long way in terms of kind of mitigating the penalties or the other things that may happen in there when they make their final rule or agreement. Another thing that makes up a good faith effort is follow up on complaints and concerns. It sounds simple, but if you recall 3 or 4 of the cases I just mentioned, one of the things that precipitated the lawsuit was because the state or local government didn't respond to complaints or concerns. So try to work with your constituents or whoever made the complaint and see what you can do to address their concerns. Training for employees, that's part of a good faith effort. I think I've talked about that already, and I commend all of you for attending today. And I'll emphasize again, make sure that's documented somewhere in your agency's records and really should be part of your transition plan to show that you're taking this issue seriously and you're making a good faith effort. And then document exceptions or technical infeasibilities, document training, anything related to accessibility. Document complaints that come in and when you responded to those and how you responded. Can't minimize the importance of documentation. And then, of course, and this may be a challenge in many communities, but allocate resources for removing obstacles, for rebuilding sidewalks, or for installing curb ramps, widening sidewalks if they're too narrow, whatever the case might be. And then include that in your transition plan. Show, hey, this is what we did in the last 2 years. These are the barriers we removed. This is the progress we've made. And then last but not least, communicate and coordinate with adjoining jurisdictions so that people can move smoothly, seamlessly, say from one municipality to the next or from one county to the next, but also with property owners so that people can move smoothly from the sidewalk in the public right-of-way to various businesses or public facilities adjacent to the sidewalk. So any questions or concerns about any of those items that we talked about? That's sort of the background and introduction to the topic. Now we'll start looking at specific details. Mike, I don't know if any questions have come in up to this point.
Hi, Ron. Thanks. We do not see any questions at this time, but as a reminder to our audience, the questions box is available, so please feel free to type in any questions at any time.
Thanks, Mike. Well, then next, let's look at the self-evaluations. So this is the ADA self-evaluations. These are required of all public agencies. There you can see the citation to the Code of Federal Regulations. The due date was January 26th of 1993. And the requirement is that public agencies shall, there's that word shall again, evaluate current services, policies, and practices. So this is in the broadest sense. So this means like whether council meetings are accessible, or your courtrooms are accessible, polling places are accessible if you're a county, that sort of thing. But we're going to focus for the purposes of this session today and tomorrow just on the public right-of-way aspect. So we're going to look at sidewalks, crosswalks, curb ramps, that sort of thing. And so as part of that, evaluate the effects thereof that do not or may not meet ADA requirements. So you can kind of put it in more general terms for the public right-of-way. The agency should be looking for barriers to mobility. So for example, if you recall that street corner I showed you in West Virginia where the four people were standing on the corner, that would be a barrier that should be in the transition plan. There was no curb ramp at that, or curb ramps, plural, at that corner. So that's a barrier. A heaved up sidewalk slab in the middle of the block where the tree roots have raised the sidewalk slab, say 3 inches high, that's a barrier to movement. So that needs to be identified as part of the self-evaluation. A sidewalk with a steep cross slope, that's a barrier to movement, so it needs to be identified. How about this? I mean, I mentioned utility poles in a sidewalk are bad and can be a barrier, but here's a double pole. And with the signal controller box, I guess that is on it, this is, I would say this is a totally inaccessible sidewalk. This sidewalk has significant barriers, 2 poles and the controller box. So this set of barriers here should be identified on that agency's transition plan. There's not 3 feet here, certainly not 4 feet. Anybody, even an able-bodied pedestrian, it appears, will have to step into the street to continue on that sidewalk. And then this controller box, notice it's mounted on the pole, and this is what's called a protruding object hazard, meaning it's above cane detection height. It's above 27 inches. And so a blind pedestrian using the cane will run into it before they detect it with the cane. So that's one of these accessibility, but also a real safety issue. And offhand, I'm not sure what the solution to this situation is. I'm not sure if this is a stop line or a part of a crosswalk, but anyway, we'd have to see the bigger picture to know how to correct that situation. But clearly that's a barrier or obstacles that need to be identified in this as part of the self-evaluation. And then once these barriers or obstacles are identified, the entity should proceed to make the necessary modifications. And that gets into the transition plan, which we will talk about. But I did want to emphasize that a key part of a self-evaluation is that there should be an opportunity for public participation. Well, not should be, there needs to be it's really a requirement. There needs to be an opportunity for public participation, but more than just the general public, individuals with disabilities and organizations representing them need to participate in this as well. So may need to be proactive here to make sure that we bring in individuals with disabilities and their relevant organizations that advocate for them. They need to be part of that self-evaluation process, and that needs to be documented. When it comes to self-evaluation and transition plans, The ADA makes or identifies kind of two categories of entities. The first is public entities employing 50 or more people. And this means in the entire organization, not just in the street department or public works, in the entire organization. And they include in that temporary employees. So for example, some communities may hire like college students during the summer for maybe parks and rec activity or certain maintenance activities. Those employees may be called or considered temporary employees because they're just there for, say, 3 months in the summer. But those would count toward that 50 number that you see there. So these are the larger agencies. The requirement is to maintain the self-evaluation. That's what SE is, self-evaluation. Maintain that self-evaluation on file and make it available for public inspection. And also that self-evaluation needs to include the list of interested people consulted, which should include individuals with disabilities, a description of the area examined, which would, if you're a town or a city, it would probably be everything within the city limits, should be the area examined. And then the problems identified, meaning maybe a curb ramp was missing on the corner, maybe a heaved up sidewalk slab in the middle of the block, maybe a steep cross slope at a driveway, those kinds of things. Identify the problem, and then a description of the modifications that need to be made to remove that obstacle. And now this is kind of grading into, or transitioning into, no pun intended, into the transition plan, which identifies the corrective action and the schedule for making that corrective action. And we'll talk more about the transition plan here shortly. What if the agency has less than 50 employees? I've heard some folks tell me, well, that means we don't have to worry about this. Well, that's not true. That's a myth. All agencies have to make sure their facilities are accessible and have a plan for managing accessibility. So if you have less than 50 employees, you still have to do the self-evaluation. It's said it should be documented, but my personal opinion is I don't know how you can demonstrate that you've done something unless you document it. So to me, it needs to be documented. And just as with the larger organizations, you need to list the people that were consulted, which should include individuals with disabilities, description of the area examined, so everything within the town limits, and what problems were identified and where those are located. I guess the main thing is it doesn't have to be as big a deal as for the larger entities. Just as I say here, something that substantiates that you know where your barriers are and you're working to remove them. But again, I'll repeat, all public entities, regardless of size, even if you have, say, we have a West Virginia community that is basically three people, the mayor and 2 council people, and they also serve as kind of the public works department. They plow the snow in the winter and clean the ditches and prune the vegetation in the summer. The mayor came to me and said, well, there's just 3 of us. We don't have to comply with this, do we? And my response was, even though there's only 3 of you, you still have to make your facilities accessible, and you should have a plan for managing that accessibility. So it doesn't matter how small you are, agencies still need to comply. I mentioned the public outreach, involvement of the disabled community. This, if you announce a meeting, people may not show up. So you need to be proactive and reach out to groups and get them to the meetings or to whatever forum you're using to get input. And notice comments can be obtained through forms at meetings or meeting transcripts, a hotline, an email address, maybe on the website, or a postal address. Keep in mind that with disabilities, people may have a variety of different sort of capabilities. Not everybody may be able to write. Not everybody may be able to use a keyboard. Not everybody can hear. And so it's important to give people a variety of mechanisms to participate. Don't just say, it's not appropriate to say, for example, comments must be in writing, because that's too restrictive. Not everybody is able to write. There should be a variety of mechanisms where folks can participate. So that brings us to transition plans. So we have the self-evaluation, and then this sort of grades into the transition plan. The self-evaluation identifies the barriers, the obstacles, what needs to be done to remove those barriers. And now the transition plan gets into scheduling of when these barriers will be removed, what the cost will be, and those kinds of issues. And again, we have that 50 or more and less than 50 distinction. So for the larger organizations, 50 or more employees, transition plans are required. The deadline to complete them was July 26th of 1992. And remember that CDR versus Caltrans, that lack of a transition plan is by itself an ADA violation. So if your agency doesn't have a plan, seriously need to do it now. It's imperative. And as I said, give yourself credit for attending this training and call that the first step in your transition plan process. But it's something that could be done, as soon as possible after these sessions today and tomorrow. But not only is it important to have one, the transition plan is supposed to be a living document. So it needs to be periodically reviewed and updated to, as it says here, ensure ongoing compliance. So if maybe some of you have a transition plan, but maybe it's been a decade or more since it's been looked at, it's important to, again, relatively quickly review and update your transition plan. As I mentioned, they should be a living document, need to update regularly to reflect changes in the real world conditions. Now, sometimes I get questions of people ask, well, what do you mean by regularly? Is that 5 years or 1 year or 2 years? And I've tried to ask attorneys who deal in civil rights and ADA issues for help on that. What do they consider regularly? And of course, it's hard to get people to pin anything down. They don't want to put it in writing. But my sense is, and this is just Ron's sense, my sense is that regularly is probably around every 3 years or so. You should be updating your transition plan. So, and if you do say every 3 years, then you can say, yeah, we are regularly updating our plan. But remember, I talked about how your transition plan, not only does it need to talk about the barriers, but to me, it should talk about what progress you've made and what training your staff has undergone. So, in that transition plan, maybe right up front, it should start with, this is what we've done in the last 3 years. This is how many barriers were moved, how many curb ramps we installed, how much training our staff underwent, that sort of thing. But also, of course, the infrastructure, the built environment changes over time. The utility may, put another pole in the middle of the darn sidewalk, or as I say here, maybe one of these newspaper vending machine kind of things gets installed downtown that reduces the width of the sidewalk. There's all sorts of things that of course happen out on our streets and sidewalks, and those changes need to be included when the transition plan is updated. That brings us to this what do you think image. This is a small city in Pennsylvania. This is basically a residential district over here on the right. There's a series of row houses that are probably over 100 years old. It's a nice, quiet residential community. This is brick building we see here is the high school in the city. It was built about 95 years ago and stayed like that until a few years ago when they put an addition to the back of the high school and they added a new parking lot here. So we can't see the addition, but we can see the driveway. This is a new driveway to the parking lot that serves the school and the addition to the school. Driveway was built, this sidewalk along the street was continuous. But as part of this project, and I don't know if this was a design issue or a construction issue, but notice this grass island here goes all the way out to the street. So now this sidewalk is obstructed. All pedestrians to continue on the sidewalk have to walk into the street, which is not good, not safe necessarily. So again, I don't know what happened, but somebody dropped the ball either in design or construction. Of course, this island to me should have terminated back here, so we have a full width sidewalk continuing along that block. So that's the main issue I wanted to talk about on this slide, is that barrier that was created by brand new construction, and now should be on the agency's transition plan. Although, you know, to me, had somebody been inspecting this, somebody should have probably caught that from an ADA perspective. But also notice here, and you can't see it, there's a sidewalk along the edge of the parking lot or driveway here. And I think you can see there's a ramp that comes down. And so whoever designed this put in a detectable warning surface, the truncated domes here. And the truncated domes are a detectable warning surface. As the name implies, they warn the visually impaired that they are about to enter the street. And so the visually impaired, the blind and low vision pedestrians, should stop and check out the situation through hearing, listening for traffic sounds. But I have an issue with this here, because notice this detectable warning is what, maybe 10 feet or more from the street. So when they cross the detectable warning, they're not entering the street. So that's kind of misleading information that's being presented to the blind. But even if they were going to, say, cross the street, which this implies that there is a street crossing, I would say as a traffic engineer, I don't want visually impaired pedestrians crossing in the middle of the block where there's no marked crosswalk. So actually, to be correct, this detectable warning surface does not belong here. It should just be a smooth concrete surface. So there are really two issues in that scene that I wanted to mention. I mentioned the transition plan requirement if an agency has 50 or more employees. What about the smaller agencies, less than 50 employees? Notice you're still required to ensure that your programs, services, and activities are accessible to individuals with disabilities. You don't have to have a, quote, transition plan available for people to inspect. But personally, I think it's in your best interest to have a plan for managing accessibility. You don't have to call it a transition plan. It doesn't quite have to be as big a deal as for the larger entities. But as I said before, to me, every entity should have a transition plan, a self-evaluation and some sort of plan for managing accessibility. And that will go a long way if there's ever a complaint or investigation. I think you'll be in much better stead if you comply with these requirements. So what goes into a transition plan? And notice I say this is for the public right-of-way. An agency transition plan really needs to include all programs, services, and activities. So are council meetings accessible? Is your website accessible? Are the park and rec programs accessible? So an agency's transition plan would need to include all of those things. but we're just going to look for purposes of this class at the public right-of-way portion. So the streets and sidewalks and traffic signals. So as we talked about, the transition plan should incorporate the results of your self-evaluation. Should be a list of physical obstacles that limit accessibility. And then a detailed description of the methods that will be used to remove the barriers. Like maybe there's a barrier at the northwest corner of 5th and Maple Streets because there's no curb ramps. That's the obstacle. The description of methods would be to install 2 curb ramps, 2 perpendicular curb ramps on the northwest corner of 5th and Maple, and then a schedule. So say in 2026, we're going to install those curb ramps at the corner of 5th and Maple. Or maybe the barrier is a heaped up sidewalk slab. We're going to remove that in the summer of 2025. And maybe to do that, we maybe need to remove a couple slabs, do something with the tree roots, and then replace the slabs. The transition plan needs to include the name of the individual responsible for implementation, and then notice a schedule for providing curb ramps. I keep saying curb ramps are considered the basic element of accessibility, so they should be the top priority. So notice I'm suggesting have a separate schedule for providing curb ramps. And then, again, last but not least, make sure you can demonstrate that the disabled community has participated in not only the self-evaluation, but also the participation in the preparation of the overall plan, transition plan. Some other notes on the contents. There should be, in my opinion, a separate curb ramp installation schedule as part of the transition plan. Again, kind of highlighting the importance of curb ramps. And also, as I keep mentioning, training is an important tool for ensuring compliance with the ADA requirements and completing the plan. And so that should be, in my opinion, part of the transition plan. Identify the employees, what training they underwent, when the training was held, that sort of thing. Again, that's part of that good faith effort. Speaking of training, here's another what do you think slide. This is a city in West Virginia. Every fall they have a very nice fall festival. I forget the full name of it, but it brings in tens of thousands of people. They have a lot of activities. It's great for economic development, kind of promoting the city. And in fact, for probably a week or 10 days before the festival, they have a team of volunteers that goes around, sprucing up the downtown to make it attractive and inviting for attendees at the festival. And actually, they give these volunteers, they give them the PPE vests, and they give them maybe a half-hour training on safety and personal safety and just public safety. But I guess I would suggest that maybe they also include some training on accessibility, because I took this photo a few years ago at one corner, and notice this is the signal pole with the push button on it. And they've certainly made it attractive with all these planter boxes here, or boxes of flowers. But notice that now this push button is inaccessible. Even an able-bodied pedestrian, I don't think, can make their way to that push button to activate the push button, let alone someone in a walker or in a wheelchair. They can't really get to that device. So this is now, and I realize this will only be here for a long weekend at the festival, but that's temporarily an inaccessible pedestrian push button. And so I think with a little training and maybe education, the volunteers that spruce up the downtown could still have an attractive downtown, but also make sure the accessibility features haven't been adversely affected. In this whole transition plan process, probably the most time-consuming element or phase is to do the self-evaluation or the inventory of barriers. And here are some possible approaches, on the ground, boots on the ground surveys, kind of walking surveys, windshield or drive-by surveys, aerial photo studies, maybe using Google Earth to identify, or Google Street View to identify some issues, maybe review of drawings and plans, or actually the truth is probably your approaches are going to be a combination of all of those items that you see on the slide there. And sometimes this can be done by staff, or sometimes a community may hire, say, some college students, or larger communities may retain the services of a consultant to collect that information. So do what works best for your community, given your size and your resources. Remember, I said a schedule needs to be part of the transition plan. So that involves setting priorities for implementation of the upgrades. Remember, curb ramps probably should be first priority. And I would also add that the schedule should be reasonable and defensible. I was talking a few months ago to a mayor of a historic city, and they were way behind in curb ramp construction. A lot of intersections didn't have curb ramps, and he showed me their transition plan, and he was showing some curb ramps being installed in like 2035 and 2036. And I commented, I said, curb ramps are supposed to be a top priority. And if you're talking about 2035, that's 10 years from now. That's 45 years after ADA. I think you'll have trouble defending that if there'd be a complaint or an investigation. So make sure your schedule is defensible and reasonable. Other things to consider in developing a transition plan: have a procedure for installation of accessible facilities, which kind of relates to maybe the third one there. Have an avenue for citizens to request curb ramps or accessible signals or sidewalk repair. And then that may cause your transition plan to change priorities, because if citizens request something, that should probably be a higher priority, make that a higher priority than it might otherwise have been. Monitor the transition plan via milestones. And as I mentioned, in the next iteration of your transition plan, have a section that shows what you've done. What progress have you made? Highlight what you've done. And those of you that may have sort of a pedestrian master plan or bike pedestrian plan, maybe may want to incorporate or coordinate the transition plan with those pedestrian related plans or features. And I think we're running out of time. Mike, this is probably a good place to stop for today, and we'll pick up tomorrow and finish transition plans, and then we'll get into the case study. So again, a reminder to everyone, if you get a chance, if you might review or read that Village of Lyons transition plan, that would be helpful. And then we'll also tomorrow get into an agency to-do list for folks where they can see what stage of the process their community might be in. So thanks everybody for your attention. I think I'll stop here for today and wish everybody a good rest of the day. See you in the morning. And Mike, I'll turn it back to you for any closing comments.
Yeah, thanks, Ron. We do have one question from Letty, and I've copied her question into the chat there for you.
Okay, thank you, Letty. Letty says, for APS, can you provide guidance on what is considered an alteration of a traffic signal? For example, common maintenance of traffic signal is rewiring or replacing vehicle heads or pedestrian heads. Would this maintenance be considered an alteration? Great question, and that's a common question. And that is one of the gray areas of ADA or PROAG. But your example there is rewiring, which rewiring, that's a gray area, I guess, but replacing vehicle heads or PED heads, as I understand it, that is considered to be an alteration. The wiring, I guess I won't give you an answer because I think that's a gray area. I'll say it depends. But yeah, my understanding is if you are replacing a vehicular signal head or a pedestrian head, that is considered an alteration when it comes to APS. And I think there'll probably be more guidance, as I understand it, forthcoming once the US DOT and DOJ adopt the final rule of PROAG. At least that's my hope. But thanks for that question.
All right. Well, thanks, Ron, and thanks everybody for attending today. And we will pick up tomorrow morning at 10 a.m. So we look forward to seeing everyone tomorrow for day 2 of this webinar series. Thanks so much.
Thanks, everyone.